I'll believe it when I exactly.
Exactly. Because that effect goes in on the 31st or the 1st?
I believe it's the end of the month,
End of
so
the
it'd be
month.
the
So it'd be
31st,
the
yeah.
31st, right? So that noise ordinance that we've talked about pretty much each week here on the show, finally, pretty much counting down the days till it goes into effect will happen here. And in the next couple days, actually.
Yeah,
Um,
that's what they say,
that's what they say. So we'll have to wait and not hear. But
hopefully,
Mo,
hopefully.
in the meantime, what do you got for us today?
Well, we got, everyone's favorite topic, alimony reform.
Yes.
So, as we've talked about on the show, it's been a few years actually at this point, um, but there's been an alimony reform bill that's kinda gone through the Florida legislature many times. It's never passed. It passed one time, then got vetoed by the governor. It's never become law, basically. So, back in the 2022 session, we do have a new bill that proposes to end permanent alimony, which has been part of the prior bills that have been introduced over the years, but none of those have succeeded. So right now, they do admit that this bill still needs some tweaking, but this is kind of the introductory version of it. And it passed its first committee on a 6-3 vote. Basically, what it's proposing to do is end permanent alimony in all divorces going forward. So we'd still have the other types of alimony. We'd still have bridge the gap alimony, rehabilitative alimony, and durational alimony. And so, just for the listener's purpose, durational alimony is just alimony for a duration of time, so just a number of years. Um, Rehabilitative alimony is just kind of get somebody back on their feet. Typically, you have to do a rehabilitative plan. As far as that's usually involves someone going back to school, getting some sort of new skills, training, experience, something along those lines. And bridge the gap is just kind of alimony to kind of bridge that gap until you can get a job, again, get back on your feet there. So those types of alimony would still remain in place. The big difference is they would be eliminating permanent alimony, which basically is alimony for life. Now, when they say alimony for life, you do still have a right to retire. The problem is that you have to go back and modify the alimony. And so I know the big question people have out there right now is if I'm currently paying permanent alimony, how will this impact me? Unfortunately, the answer is it won't impact you.
Oh,
It has no retroactive
it's only
announcement.
going to be
It's
moving
only going
forward.
moving forward. So, um, and the problem with that is there's a constitutionality problem with having it go back and affect divorces that have already been done. And that was one of the reasons that it didn't pass previously was kind of this retroactive aspect of it. The other reason it didn't pass previously was because they also dropped in something where there was a presumption for 50-50 time sharing or 50-50 custody. And basically, that didn't fly very well.
I'm just trying to remember because there was another alimony bill back in like 2019 with about the money being deductible, tax deductible, the person paying or receiving.
So that was
Is
the
that
tax bill. So that was on the
so?
federal level. So
Okay.
that was the revision of the tax code that was done. Yeah, it was what 2020, I think 2019,
Something like
2020.
that, yeah.
And
But
so
so it's not related to this at
not
all.
related.
Okay.
So this bill is the one that you know there's a
It's
lot.
strictly time.
It's strictly in Florida. It's strictly affecting the permanent alimony aspect. So right now in Florida, if you're married 17 years or longer, there's a presumption that you should be paying permanent alimony. What this bill would essentially do would wipe out permanent alimony. So we no longer have that presumption. We no longer have permanent alimony. What the judge could do is award durational alimony, which, like I said, is alimony for a duration or a period of time. Currently, under the current law, that duration of time can be up to the full length of the marriage. So if you've been married 17 years or 18 or 19 or even 20 years, the judge could award it up to that full 20-year period. Under this new law, they can no longer award it for quote unquote life under the permanent alimony. Now, again, permanent alimony, if a judge awards it, it is always modifiable. So then when that person retired or if their income changed, they would have to go back to court and modify the alimony. Now, anyone who's done that before can tell you it's a headache. It's basically it's another lawsuit. It's just like a whole new divorce. You have to do all the financial disclosures again. You have to go through the whole process again, and it can be expensive. And you may not completely eliminate the alimony too. You may still be paying some sort of reduced amount because you may still have income from a pension plan or savings or or the residuals off your stocks, or interest is considered income as well under the statute. So there's a number of ways you still may have income even though you're not working, which may prevent you from being able to eliminate that alimony altogether. So that's the purpose of this bill, is to get rid of permanent alimony. It's something that's been around, that people have been pushing for a number of years now. Um, so far, the family law section of the Florida bar has not endorsed this bill, as well as the American Academy of Matrimonial Lawyers have not endorsed the bill yet. Both sides are basically saying we like where this bill is going, but it's not complete yet. So we're still kind of waiting to see all those other provisions before we get behind it and say whether we're going to endorse it or not.
So what are the chances of this bill getting passed, do you think, in your opinion?
Well, I mean, it depends what they're going to put in there, right? So that's what we always see is, I think it was the last time this went through the legislative session, it looked pretty good. It looked like it was going to pass until someone dropped in the 50-50 time sharing presumption. And what I've kind of been told is that the legislator who did that was going through a very bad custody battle himself, which is why he put that in there. That kind of side railed the whole deal. And so that killed the bill essentially. Previously, before that, it did pass, but then it got vetoed because of the retroactive application that bill had. So, assuming they leave out the retroactive bill, assuming they don't put anything regarding time sharing in this bill, assuming that it doesn't get kind of mucked up with other provisions, or they don't try to tack other things onto it, I think it would probably get pretty good support to eliminate permanent alimony. It's something, a lot of judges don't like awarding permanent alimony. Everybody kind of understands that people are entitled to retire, but if a case right now goes to trial and it's over 17 years, like I said, there's a presumption in favor of permanent alimony, and in most cases, the judge really doesn't have any choice but to award permanent alimony, frankly.
Yeah, and that will now kind of change the way that we see people kind of approach these negotiations and
Well, that's always been one thing, in the negotiation process. So let's say you have a 20-year marriage, a long-term marriage, and there's a presumption in favor of permanent alimony. If you're the one who's looking at potentially having to pay permanent alimony, that would be a reason that you would want to try to settle the case before it went to trial, because the judge can only do one thing, basically, award permanent alimony. If we do a settlement agreement, we can build in a termination date. So we can, look at the prospective age of retirement and say, okay, we're going to, pay alimony up until this day when we think he's going to retire. Now, typically, in order to negotiate that, you may have to pay a little bit more. There has to be some sort of, sweetener, so to speak, to get the other side to agree to it. Because the other side knows, if they know what they're doing, that if it goes to trial, they're going to be awarded permanent alimony, basically. So that's kind of the analysis that goes on now is, if you're looking at paying permanent alimony, you're looking to try to negotiate that away before it gets to trial, because if it goes to trial, that the judge really doesn't have any choice but to award it.
And so now we'll kind of just see the max amount. Is there going to be a set number, do you think?
No, this only goes to the duration. It only goes to the number of years. And I would guess that the set duration would be up to the full length of the marriage. So if you're married 20 years, the judge could award it up to the full length of the marriage. And they're going to look at the circumstances of the marriage. They're probably still going to consider the retirement date. So, if you're in a 20-year marriage and you're at 55 and the judge says, okay, I think you're going to retire at 65, some judges may award it for 10 years there. That may be the argument that is made. Again, this is all kind of speculative, and this is, this bill is in the very infancy stages at this point. So we'll continue to monitor it. We'll continue to update you as far as where it goes. But if it does pass, then I think it probably would remain. The judge could award it up to the full length of the marriage, but they're going to consider other factors such as, prospective retirement date, the financial abilities of the parties to work, all that kind of fun stuff.
Good stuff there, Mo. It'll be a hard cap, essentially, though, on just however long the marriage was.
That would be my guess. That's the way the statute is written right now. My guess is that part would not change. It would still be up to the full length of the marriage, and that would be the hard cap.
Okay. That would be interesting to see if that's maybe one of the things that they would try to change at the last minute, or put in or adapt or something. I don't know.
Well, if they do, it could be a potential bill killer there. It could kill the whole deal. Hopefully they won't do something like that, but we'll see.
We will see.
Yeah.
Good stuff there, Mo. If you want to go ahead and send us an email, we'll get to those emails coming up here. Don't forget, you can send them in at ask@DeWittLaw.com. It is ask@DeWittLaw.com. If you have a question about what we are talking about, maybe you yourself are going through divorce and have a question about what Mo was talking about there, you can send him that email, ask@DeWittLaw.com. That is ask@DeWittLaw.com. Also check out DeWittLaw.com. We'll be back. We got plenty more show coming up here. You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580.
Story time. So I want to tell you a little story about a call I got about a year ago. This guy gave me a call. He was just in a car accident. And I talked to him for a while. I told him what to do. Told him he needed to go seek medical treatment and get checked out. He said, thank you. I appreciate your time, but I'm not going to hire you. So not a problem. If you have any questions, concerns, let me know. Happy to talk to you anytime. About 2 weeks later, I was actually in the Bahamas. About 2 weeks later, he called me back and he goes, spoke to the insurance company. They're offering me $770 and they're saying I'm 30% at fault for the accident. You're hired. Sent him the paperwork, got him signed up. That was about a year ago. Today, we just settled his case for $100,000. The insurance company wanted to pay him $770 to resolve that claim. And this is just a prime example as why you should never settle with the insurance company that soon after an accident. You don't know what your injuries are. You haven't gotten checked out by a doctor. You don't know if you're going to need surgery or if there's a tear in a ligament or something more substantial. So when the insurance company offers you quick money after an accident, typically they're offering you pennies on the dollar to go away. And the last thing they want you to do is to hire an attorney because they don't want to pay you the fair compensation that you deserve.
Welcome back to the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's News and Talk. Don't forget, check out the DeWitt Law Firm on Twitter, Facebook, TikTok, YouTube, wherever you might get any social media. Mo does a lot of great stuff with what he does on social, a lot of fun stuff, a lot of interesting stuff, and stuff that probably any other lawyer is not doing right now in a very fun way. So you got to check some of that out. And then, of course, if you like what you hear on the show, we are putting past shows up on YouTube, and this show will be on YouTube as well. So if you missed some of the beginning of the show or you want to go back and watch it again, you can do that on YouTube and see our beautiful faces that aren't just made for radio. They're also made for YouTube, apparently.
Apparently just YouTube and Facebook.
YouTube and Facebook. We're cool with that. Mo, a couple things in the news that I just wanted to get to briefly here. First, on a national scale, we had a Supreme Court justice step down. And normally it's not necessarily like very common thing to see.
Well, so
at least like
any federal court judge is a lifetime appointment. That's different than a state court judge. So in the state of Florida, at least, the mandatory retirement age is 75. I think it used to be 65, and they bumped, or maybe it was 70, but it's bumped up to 75 now. On the federal level, though, those judges are appointed for life. So that's why a lot of times we see judges who pass away in office. Essentially, they stay the entire time. But here, is a voluntary retirement. He decided to retire, and they're certainly able to do that at any time, just like any judge can, frankly. But those positions are very, very unique because they are lifetime appointments, unlike, state judges who are elected officials. These are judges who are appointed. I think they're appointed under Article 2 of the Constitution, if I remember correctly. Or maybe it's Article 9. I could be getting those mixed up. I'll have to go back and read my articles again. But they are federal lifetime appointments. They are there for life. And so, when someone retires, especially at that level, at the Supreme Court level, it is a big deal for obvious reasons.
I'd be curious, and I'm trying to look it up on the fly, but I can't, as to how many of them retired versus how many have passed while serving.
I would probably venture to guess there's probably a pretty even split of that through modern times, at least. I'm sure you have some people who are just had enough. Frankly, they want to enjoy retirement. Other people are probably very passionate about it and want to stay there the entire time. But they're certainly welcome to stay as long as they would like.
Yeah.
So,
and then briefly, let's touch on this because this is a local story of the Mia Marcano law that's being kind of put in, or the bill that's being sent in. They're talking there to help secure apartments a little more, which I think in light of this story and learning about the background of it all is something that needs to happen.
Yeah. So again, this is another bill that's making its way through the 2022 legislative session. Right now, I think it's still in the Senate Judiciary Committee. But basically, what they're looking to do is increase background checks on people who work at apartment complexes, force apartment complexes to have master lists of people who have access to the master keys to get into the apartments, and then require a 24-hour notice to enter the apartment. So I think the idea there is, you have to give more notice, limit the people who have access to the keys so that if a key goes missing, they kind of know about it and they know who's taking the keys. And then, of course, have more uniform background check procedures to do so everyone who works there has to have a national background check, as well as a few other levels of background checks that are outlined in the current version of the bill to ensure that there are not bad people working at these complexes who have access to keys for everyone's apartments who live there.
Yeah, it's something that I think a lot of people kind of see and we're like, yeah, that seems like the
Makes
right
sense.
thing. It makes sense to
Yeah.
do, especially in light of what happened. And I imagine that this will pass through without any issues.
It seems like it has good traction so far. There could be tweaks to it here and there, but I would imagine that it seems to have good support so far. So we'll see where it goes from here. But yeah, I would venture to guess if I was a betting man that some version of it will certainly pass. Hopefully.
Yeah, well, I'm not a betting man either, but if I were to bet, I would too. That's totally lying. You're listening to the DeWitt Law Review here. We still got a whole another half-hour show coming at you. We've got emails to get to, and we've got, of course, the Moe Pro tip of the week, which you want to stick
Absolutely.
around for as well. So stay tuned. We got plenty more show on the way. You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580, Orlando's News and Talk.
We just got this client $25,000. I don't show it to you because it's a giant check. The important thing here is the initial offer was only $2,500. That means we got them 10 times the initial offer. Without an attorney, in my opinion, he would have never gotten this amount. The insurance company's own study shows that when you have an attorney, on average, you get over 3 times more than those who go at it alone. In this case, we got 10 times more. Injured on the go? Just call Moe.
Welcome back to the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's News and Talk. Just a reminder here, if you want to send an email like we're the ones we're about to go over, you can do that at ask@dewittlaw.com. That is ask@DeWittlaw.com, ask@dewittlaw.com. Also check out dewittlaw.com where you can submit a case evaluation if you want. Check out past archive shows, the legal blog there as well. Mo, let's go ahead and dive into these emails here. We got a few to get to. First one, I hear you talk about uninsured motorist coverage all the time. Why is it important to have on your policy and why it's important to have on your policy? However, wouldn't making a claim against your uninsured motorist policy raise your rates and or possible to have your insurance company drop you?
So that's a great question. That's something
That's
that,
a very good question.
yeah, I mean, we face that a lot of times when, I think it's 20, the other day I was looking up the statistic. I think it's 26.7% of drivers in Florida are on the road and uninsured. Not to mention, we also are the only state in the nation that currently does not require bodily injury coverage, which again is why it's so important to have uninsured and underinsured motorist coverage on your policy. But then when someone's in an accident, the other driver doesn't have insurance. A lot of times we hear that exact question. Well, I don't want to use my own insurance because I don't want my rates to go up. I don't want to get canceled by my company. So under Florida law, they're legally not allowed to raise your rates or cancel your policy unless you have 3 accidents within a 3-year period. So that's when they can raise your rates. But as long as you don't have 3 accidents within a 3-year period, they're legally prohibited from raising your rates or from canceling you from the policy. Now, one thing to keep in mind with that, though, is if you have like good driver incentives, sometimes they'll
Right.
that kind of thing. They can take off kind of the incentives, but they can't actually raise their rates, if that makes sense.
Okay.
So that is something to keep in mind. But from a pure legal perspective, the statute actually prohibits them from canceling you or from raising your rates, but they can still take off some of those incentives if they're giving you, discounts or bonuses on other aspects of your policy for not being in an accident. So something to keep in mind. I still think it's extraordinarily valuable coverage. I recommend everybody
I
has
think
it.
that I think it's important to maybe just as much as we do talk about it, talk about why it's important to have.
I mean, so what uninsured motorist coverage does is if someone hits you and hurts you, and they don't have the insurance to cover the damage that they cause, that uninsured motorist coverage steps into the shoes of the at-fault party. So they basically act like the insurance coverage for the at-fault party and allow you to collect from them for your injuries, for your medical bills, for your lost wages, for all those kinds of damages. So that's why it's so important in Florida, because we're not required to have bodily injury coverage. That's the coverage that normally covers if someone hits you and hurts you. That's the coverage that kicks into place. That's the coverage that the at-fault driver has to cover the damage that they caused. Since you're not required to have that, someone can legally be on the road, ram into you, cause a bunch of injuries and damage and everything else, and not have any insurance to cover it. So that's why you want to have uninsured motorist coverage on your policy. Not to mention, there's almost over 25% of people, over 1/4 of people on the road don't even have insurance. Not talking about the people who are legally driving without bodily injury coverage, just don't have any insurance at all, according to the last statistic I read. So, in Florida especially, extraordinarily important coverage to have to protect yourself and protect your family, and make sure that if you are in an accident, you don't have to basically play the lottery as to whether that person's going to have insurance to cover the injuries that they may cause you.
Yeah, and that's again why it's one of those things that is something to keep in mind, as you mentioned, but it's important to have and something you definitely want.
Hugely important.
Let's go roll on to our next email here. I lived in Kissimmee in a subdivision for over 20 years. Last year, the association contracted with a cable company, imposing it on all their residents to sign up for the service. Is the association required to provide residents with different companies to choose from, not just one? And if their service is not reliable, is there a way out? Thank you.
So, under the Florida statutes, the association's prohibited from signing basically an exclusivity deal with one company. So, what the association can do, though, assuming they follow their bylaws and the declaration and go through the proper procedures, is they could certainly sign a deal with one cable or internet provider to give a discount to their residents. That being said, they can't prohibit the other providers from coming into the homeowners association. So while they may have entered into a contract with one provider to give a better rate or a better package or whatever it may be, it is actually illegal for them under Chapter 720 to prohibit other providers from coming in or prohibit you from being able to sign up with other providers.
Now, but what about apartment complexes? Can't those kind of regulate in a way?
Different statute.
Okay.
So this is Chapter 720, which is the homeowners association statute. Chapter 718 would cover condominiums, and that's a different statute entirely. And then apartment complexes are a private entity, so they have different rules and different regulations as well. So three different areas, three different types of buildings essentially. But under the homeowners association statute, they cannot prohibit you from using another provider if you want to do so.
Interesting. Okay, that's a good one there. Another good question. We got a couple of
Yeah.
good ones here. Let's go on to our next one. Again, if you want to participate, you want to ask an email or send an email to Moe, that's ask@dewittlaw.com, ask@DEWITT law.com. We currently have 3 federal tax liens on our home due to unpaid taxes. He disclosed this to me after he was not having taxes come out of his checks because he couldn't afford to pay the bills. Now he wants to buy me out, and I'm looking to have the house sold to pay off the tax liens that he caused, but he wants to use his 401k to buy me out because he can't pay the tax lien, is currently on a payment plan with the IRS.
Okay, so I think this is part of a divorce.
Yes,
is the
I'm guessing
question?
so, yes, and it's having to do with what this woman can do with the house. in
Yeah.
this
So,
situation.
in any case like this with a divorce, I always describe a divorce as financial surgery. So we want any sort of joint or marital liability to be eliminated as much as possible, and certainly not for you both to be liable for it, which was what the case would be here. So in most cases in a situation like this, I would think the best route to take would be to sell the home, pay off the tax lien, and then split any remaining proceeds after the mortgage is paid and things like that. And I think in most cases that's probably what a judge would do as well, because they want to make sure that that tax lien is not going to be, you're not going to be jointly liable for it. Because again, divorce is like financial surgery. You want to be separated as much as possible. So any debts that he has, he's responsible. Any debts that you have, you're responsible for. So in this case, I think the best way is probably to sell the home, split the proceeds, and pay off all the liens associated with the home here.
But Well, it sounds like he might be trying to go a different route on this. Is he allowed to do anything, or is this going to be something that has to be settled in court?
Well, so there's only two ways to resolve a divorce case. Either the parties have to agree on a settlement or the judge is going to make a decision for you. So if the parties agree on it, they could certainly do it that way. Now, there's going to be a couple problems or potential problems with taking the money from the 401k. Number one, depending on their age, there may be a penalty to do so. There may also be tax implications to pull the money out of the 401k. If you go through the home or sell the home, you may not have those tax implications if this is their homestead and things like that, depending on the amounts. All sorts of caveats we have to put on any tax advice there because we don't give tax advice, but generally speaking, that would kind of be the way it would work. Now, the other aspect here could be is depending on the length of the marriage and how long that person's been contributing to the 401k, she may be entitled to half of the 401k. So then how does she get her fair equitable distribution if he takes the money out and then he wants to also keep the home? So there just may not be enough money to go around once you kind of do the whole financial analysis of the entire case there. So those are a couple things to look at. I think really to give a proper explanation, we'd really have to dig into the finances a lot more, see what the numbers look like, and see if there is enough money to go around. But off, kind of a cursory view, that's what it kind of looks like to me, at least.
It sounds like, though, with all of these liens and unpaid taxes, that it's going to end up costing a fair bit of money to get all this sorted out, though.
It does, and fortunately, it sounds like there's some ways to do it because there are some assets. But at the end of the day, you don't want to be jointly liable for that tax lien. You want that paid off as part of the divorce, so you can move on and live your life and not have to worry about that.
Would this scenario have all three liens, you think, put on one party? Is that how that would work, or?
Well, if it's a tax lien that was acquired during the marriage, most likely it's going to be a joint tax lien, meaning you're both going to be liable for it. So that's why you want to make sure it's paid off. Because, for example, let's say you had a divorce settlement agreement and it said the husband's going to pay the tax bill. He's going to be responsible for it. Well, that has no impact on third-party creditors like the IRS. So if he doesn't pay it, the IRS is going to come after both of you. Even though the settlement agreement says he's responsible for it, they're going to come after both of you, and then you're going to have to take him back to court to enforce the settlement agreement. So you're still on the hook there, even though the settlement agreement says he's going to pay it, which is why it's a much better...
It's easier to just have it already paid off, because then what you're doing is then you're relying on him to continue to pay off that lien, and they already haven't been paying off those liens. And then if you don't pay those liens off, IRS comes for you, and then you got to go to court to force that settlement into place. Right. And that's just a headache and a half to go through.
Yeah, I mean, whenever you're doing a divorce settlement agreement or going through a divorce, you only want to go through it one time.
Yeah.
You don't want to be dealing with it for the next 10 years, and that's why we have to kind of look at the way we design these things to kind of get a final resolution that is final, so you're not coming back with all these headaches and issues down the road.
And this is why a lot of times, well, most times we recommend that the best thing to do in these situations, kind of talk these scenarios out first and try to figure out a formidable plan for both that would benefit both you and your spouse, even though a divorce isn't necessarily a beneficial thing to be doing.
Well, I mean, it depends on your situation.
Yeah, I guess, it could be.
I always say most people don't really want to go through a divorce, but they find that there's no other option,
Right.
So, but yeah, I mean, this is kind of where experience comes in. Talk to an experienced family law attorney. They can guide you through the process on these things, whether it's us or somebody else. But there are these pitfalls and kind of these little traps that you can get yourself into. And everything works great, when everyone's being cooperative and everyone says they're going to do X, Y, or Z. But we always have to, prepare for the worst. So hope for the best, prepare for the worst. We have to kind of design the agreement that way to make it as final as possible, and so that you can move on with your life and not be constantly being dragged back into court with these kind of headaches.
Yeah, it's just not, that would just not be an enjoyable process at all. Just constantly going back into court because the divorce settlement that you agreed on has somebody paying something off and they're just not doing it, but it's still linked to you. Like, that's just it just makes me upset even to think about, Mo.
Yeah, well, we'll have to get you calmed down.
Calm down during the break. We'll come back, and then I'll get soothed over by the Mo Pro tip of the week.
There you go.
Listen to the DeWitt Law Review. Don't forget, you can email us, ask@dewittlaw.com. That is ask@DeWittlaw.com. Also, check out DeWittLaw.com, where you can submit a case evaluation. You can check out past archive shows, check out the legal blog, and, of course, don't forget, Check out Moe and the DeWitt Law Firm, all social media you can, Twitter, Facebook, YouTube, Instagram, TikTok, whatever it may be, the DeWitt Law Firm. Check them out. And on YouTube, of course, and Facebook, you can check out the past shows that we've done, recording them live on camera now. And you can go ahead and rewatch those if you missed something, you're coming in late, or if you heard something, you want to go back and take notes on it, all the same there. But again, we got one final segment coming up, Moe Pro Tip of the Week coming up, so you definitely want to get those pens and pencils ready for that one. DeWitt Law Review on WDBO 107.3 FM and AM 580.
I was visiting the local resort when I had an unexpected slip and fall. I reached out to the DeWitt Law Firm and was put in contact with Philip Wayne. Initially, the insurance company offered me a low-ball amount, and I was able to secure over 10 times that amount from Philip Wayne and the DeWitt Law Firm. I'd like to thank them for all their hard work and recommend them to anyone who's looking to have an attorney. If you're injured on the go, just call Moe.
Last segment of the DeWitt Law Review on WDBO 107.3 FM and AM 580, Orlando's News and Talk. Appreciate everyone tuning in and joining us here this week. Chris Crawford and Moe DeWitt with you on this Sunday morning, as we are every Sunday from 10 a.m. to 11 a.m. Just a reminder, the DeWitt Law Firm, you can give them a call, 1-800-DeWitt-Law. That is 1-800-DEWITT-LAW, 1-800-339-4885, 1-800-339-4885. 4885. Moe, without any further ado, what you got for the pro tip this week?
So we started off the show talking about, the Alimony Reform bill that's making its way through the Florida legislature, and we'll certainly keep you posted and informed on that. But one of the aspects of that is dealing with permanent alimony, and that bill's trying to eliminate permanent alimony, as we discussed. And we talked about, right now, if you're paying permanent alimony, basically when you retire, you have to go back to ask the court to modify or eliminate that alimony obligation. It's not automatic. You have to basically show that there's a change in circumstances that's substantial that would warrant modifying that alimony. And here's where the pro tip of the week comes in, is what most people don't realize is that even though they retire, even though they may not be receiving a salary or an income, that the court can actually impute a reasonable rate of return on any investments they have, especially cash investments, particularly.
Oh.
So if you're retiring, typically you probably have some investments that you plan on living on.
Yeah.
The court can then, like I said, impute a reasonable rate of return on all of those assets as your income, which means that you may not be able to completely eliminate your alimony obligation. In some cases, if you've saved really well, you're set up for, retirement really well, and you have a few $1 million in assets that you're going to live on, your income may not decrease at all.
Right.
And therefore, the court doesn't have the ability to modify that alimony. So these are the things that you want to be thinking about when you're entering into and agreeing to any sort of, marital settlement agreement as part of a divorce, is not just based on your income. It's not just based on your salary. They can also impute a reasonable rate of return off of any cash investments, stock investments, 401ks. Even if you can't pull the money out yet, even if you're not at the retirement age, they can still impute the reasonable rate of return on those assets. Now, they can't do a reasonable rate of return on real estate if you have homes. Now, if they're obviously generating revenue, from renters or tenants, things like that, that's a different story. But if it's just, a large home that you live in or land or something like that that's not generating revenue, they cannot impute a reasonable rate of return on real estate, at least under the current statute.
That's interesting, too, because I bet that there's a lot of people who think, like, okay, when I retire, I'll go ahead and modify my alimony payments, and then I will cash out of this stock that I've been sitting in for all these years, and I'll be set with that, even though, like, I won't have, I bet that that's a big surprise to a lot of people, and that they don't realize that that's how that can work.
Yeah, I mean, I've represented a lot of doctors who have, saved really well for retirement. One doctor who jumps out in particular because I don't think he had seen his wife in 30 years and was still paying alimony. Went to modify it, but he still had a good amount of savings, and we were able to reduce the alimony quite a bit for him, but he still had to pay some. And so, I mean, he literally did not recognize his wife. He had no idea who she was in the room because it had been that long, yet he was still paying alimony. and continues to pay alimony at a reduced rate. But, because of those investments that he has, that's still considered income.
And now I wonder that if the new bill would maybe impact this a little bit going forward because of the limit that'll now put on it.
Right. I mean,
Like it might actually help. Like while this is in place, having the new limit would actually maybe give people who have invested in stocks an opportunity to keep that for themselves.
well, the big difference would be is that there's a termination date, right? So with permanent alimony, there's no termination date. So it just keeps going.
Right.
Under the new bill, if it were to pass, there would be a termination date essentially on all alimony awards. So at a certain point, it would automatically stop without you having to go back to court and asking for a modification. I think that would be the biggest difference right there.
There you go. Another great Mo Pro tip of the week. Appreciate everyone tuning in and joining us this week. We'll be back same time, same place next week. For Mo DeWitt, I'm Chris Crawford. Don't forget, you can give the DeWitt Law firm a call, 1-800-DeWitt-LAW, or 1-800-339-4885. Everyone have a great rest of your Sunday. The Lone Ranger is next on WDBO 107.3 FM and AM 580.